Okay. We will begin then the education and programs part.
All right, this evening we have Slicey and Mr. Newsom here to share a proposal from our business computer and technology department.
I did used to see me here, but I also have.
That's not on either. So. There you go.
Good.
Testing.
No.
It's gotta be right then.
I can be
There you
with.
go.
Oh, there it is. All right. So you're used to seeing me, but I also have with us tonight, Chris Hanusa, who's one of the teachers in our business department. He is running off from here to basketball practice. So we did ask Dr. Dandridge to put us first on the agenda so that he can get to basketball practice tonight. So do you have our PowerPoint? All right. So we are here to ask to change course name and weighting of the course name. So this is an existing class in our curriculum, which
department again?
this is the business department.
Business and computer
Yep,
information.
you got it.
Thank you.
All right, so the class that we're looking at is our existing Accounting 2 class. And we would like to change the Accounting 2 class to a college and the high school class that we would do in conjunction with York College. So it is going to be the same course. We would change the name to Accounting 2 CHS for college and the high school, and we would change the value. It's currently an honors weighted course, and we would change it to an AP weighted class because all of our college level classes are at that same level. Students have to have a GPA of a 3.0 according to York College in order to take the class. And the total course of the class through York College is $200 for a 3-credit class, which is a huge bargain in the college world. This would be our first partnership with York College. The class itself for us would not change significantly. We've already shared our syllabus, the book that we're using, and so we're not looking at significant changes. They're approving it as is, and we've been able to have Andy approved quite easily because Andy is also a certified public accountant. And so whenever we throw that CPA around, York College loves that and thinks that he would be a great instructor for this course. Do you want to add anything about the course itself?
Sure. We actually started piloting an AP program about 14 years ago, and unfortunately never took off with AP. So we've been using a curriculum from Kansas State University ever since then. It's based off of obviously college and off of my own college notes. And we've been very successful in terms of how we've been able to put students from here into local community and into very much an involvement within the accounting profession. And so last few years, I've been trying to find a way to tie this in with a college since I figured the AP thing had finally fallen flat. Struck out once, but then luckily the wife of a professor that I was originally talking with was a professor at York College, and she said they'd be all for it. And after one phone call with Professor Butler at York, they said they'd do it. We sent along the syllabus, we sent along all of our materials, and we are making no changes to any of the course material or tests.
And because there are no changes on this slide, you can see that also means there's no expense to this request. All we want to do is change it in our course guide book to change the name and then to also, again, change the weight. Like all of our college and the high school classes, except the ones that we offer online through Hack, students have the choice to just take plain old Accounting 2 with Hempfield credit and not pay anything. Or they can choose once they're in the class to pay the $200 to York College to take it as a college class. So the kids have that choice. They can still take it just as a Hempfield class, or they may choose to get the CHS credit.
And you also said there was a change in the grade point requirement?
There's a change in the weight and how grade point is figured out. Currently, it's an honors level and it would move to the next level, which is
So it
the
wasn't a
AP college.
GPA tied to
Yes,
being able to take the class.
You had said there's a 3.0 GPA requirement in order to be eligible for the college and the
for
high
the
school.
college and the
For
high
the
school
college.
class. Yes,
But if a student just wants to just take it and
that they
Yes.
would just meet our regular requirements, which I don't know what they have to have in accounting one, a C
plus
plus
or
in
higher.
accounting one.
I,
You have the manual right in front of you.
okay.
Mrs. Dicey, am I correct? The 3.0 is the unweighted GPA requirement to take the course. Changing it from an honors to an AP course affects the weighted GPA for class rank purposes, right?
So the 3.0 is simply what York College is asking them to have in order to be accepted into their program. Because a student who's taking a college course has to apply to the university and
Right,
meet
okay.
their requirement. So that's their requirement. The weighting piece is after they're in the class and they're getting grades, how it impacts
Right.
their GPA.
And that's the one that drives class rank.
Correct.
Yep, okay.
Correct. And like I said, this was currently and has been for years an honors course, and we would just want to change it because all of our CHS classes are at that same college level as an AP class.
Thank you.
As far as the change, is this being proposed for next year?
That's correct, because I will start working on the course guide in November for well, I'll start in October, but in November for the following year so that it's ready for students to select to be able to take it in January when they do course selection.
And so to follow up on that, the current class is currently in our curriculum guide. So
yes.
students are currently taking the class. Is there any, I don't know if it's an optional or if I'm opening up a can of worms, but the kids that are already in it, might they want that heavier weighting?
They might want the heavier
But then
weighting,
again, they
and
might not.
want the
Right, that's-
course,
that's-
but they're already enrolled in the course.
Enrolled
So
at
we'll
the-
start this for next
For
school
next
year.
year, the change. Okay.
Correct. You
So
got it.
I'm pretty sure you said this. So it's going to be an AP course, so they will take the AP.
No, it's not an AP test. It's at the
not-
same weight.
It's not going, the same weight,
Correct.
but they won't take the test because it's not actually AP.
Correct. They would get the credits through
College.
York College.
Okay,
Simply by passing the class.
okay. And that's a $200 fee for them.
Correct.
Okay.
I always think it's a good idea if we can take all of our AP and put it into college because it only benefits our students. Do the same amount of work and get college credits and for cheaper price. Seems like a win to me.
So I just wanted to show you, this slide is showing you the 3 existing college and the high school classes that we already have in just the business department. These are through Harrisburg Area Community College, and we have those 3 already. So what's beautiful about this is if a student took all 4 of those classes, they could enter college with 12 business credits already. The CHS classes that are up there already through HAC, this is our 2nd year doing them. They are full this year. We have wait lists for them. And they're just have extremely popular. So we really are excited to add this other CHS option. Again, not a new class, just another way for kids to get college credits. We also talked a lot about industry credentials. So this is, again, just a reminder that, again, in the business department, we offer all of these industry credentials through the Microsoft PowerPoint and the Microsoft Excel Access. And so those are classes that are a little bit more designed for someone, but anyone can take these classes, but getting those credentials is really helpful if you're going right into the workforce. And then this shows you all of the CHS offerings that we now have. We now have partnerships, as I mentioned, with HAC, and we already have a partnership with University of Pittsburgh. And this would be our 3rd one through York College. And so the yellow accounting is where that one would fall into what we already have going if this one is approved.
So when you say they're credentialed, you just mean they've completed and they don't get a certificate or anything to put with the resume?
No, they do. They take it for the industry credentials. They take a test in order. They don't automatically get it. It's quite challenging of an assessment. But those industry credentials, they get a credential that can be shared with their employees, put on their resume.
And is there a fee to get that?
There's a fee to take the test, but that's in the business budget because we buy a license that allows them to take as many as, it's a lot.
Yeah.
It's not.
Covers every single student.
So there's no actual cost?
Not
extra
to the
cost to the student?
Correct.
And the teachers just, I say just administer, but it is administered by the class teacher.
That's correct.
At the end of the course.
Yep. That's just another one of our ways to fill pathways to graduation for students who might not be proficient on the Keystones. So the credentialing is something we've been increasing, and I've been sharing as we've been doing that for the last couple of years whenever we talk about pathways to graduation.
Thank you.
I'm just curious if your college seemed to be open to more.
They would
courses in the
love more
future.
courses, yes.
Okay,
So,
great.
we're always looking at our existing classes and what classes do we already teach that could have these kinds of partnerships.
Just especially for the cost. I mean, that is a phenomenal price for students to be able to take a
Absolutely.
dual enrollment course compared to even some other universities. Those costs are higher. They're not like it is if you're actually in college, but it's still very discounted. But that $200 is a significant part.
And since we are talking college and the high school, I was at HAC last Friday. I'm serving on their advisory committee for their NACEP certification, which is their national certification for their concurrent enrollment committee. And they're really doing some great things to get that accreditation, which increases the credit transfers, who will take those. They have some partnerships now with Bucknell, Lehigh, and F&M that connect their honors program from HAC into these rather prestigious schools. So HAC is doing some great things, and I'm excited that we can be helping our students in that direction too. So we have these different pathways now with University of Pittsburgh as well. And then this one through York College, which is not requiring us to do any extra trainings or anything. So we're hoping that that can be a new option for our students.
Is there anyone else besides Mr. Weiss who can teach the course?
We did talk to them about that, and as long as the teacher has an earned master's degree, we should be able to get them approved, because every time we go down this path of one of these classes, we like to have a backup
Yep.
plan in place. We already had that happen with our FCS nutrition class. The first person we had approved left the district, and we had a backup ready to go. So Tegan took that one over last year. So we're always trying to make sure that we have a backup in place.
How
And
much,
we would have a backup in place. Jay Ridinger has all the training as well.
I wanted to thank you because it sounds like this has been in the works for many, many years. So it seems like you not giving up and just going any avenue you could to get that partnership made is kind of what made it happen, and then opens up to more partnerships in the future. So thank you for not giving up and doing this for our kids, and I appreciate that.
Absolutely. You're welcome.
I seem to recall early in my years on the board discussing AP accounting, that sort of thing. So I'm glad it's come to fruition through not a path you probably expected. But it sounds good for all of our students who are interested. So thank you for that.
Mhm.
I probably missed it. How much does it cost to go to Pitt? The University of Pittsburgh for our students?
I think those are $150 a credit. I'd have to double check that. I can tell you, just because I was just at HAC, that theirs are $83.50 per credit.
Per
So
credit hour or
per credit. So most of the courses would be 3 credit classes. I'd have to double check University of Pittsburgh's, but I think it falls around that. They're paying about $150 a credit.
Okay,
I can check that out and send it to you.
so like under $500.
Yeah, regardless, they are bargain college classes.
My daughter went to a private school. Wish we had had these options.
Same.
Okay. Anything else? Any other questions? Anyone?
Thank you both.
Thank you.
Thank you very much.
Practice with time to spare. Thank you.
Do we have anything else?
That's it for this evening. Great programs.
Okay, I will turn it over to Mr. Keener.
All right. Thank you very much, Mrs. Johnson. Moving straight into the policy, personnel, and legal portion of the agenda. we are going to move policy 351 down to the end of policies for review, only because it's closely tied in with 351-1 pre-employment drug testing, the one that we're looking to retire. Those are the only two policies that there are substantive recommendations for, but I will turn it over to Dr. Musser and let him walk through 246 and then 802 through 807.
Sure, thank you. So with that change in agenda, it does make it simpler. The school wellness policy, as we're working through, as you can see, generally the 800s, is actually a policy that's due for renewal every 3 years. A lot of times this policy will come up as we're starting to get our audit from the state. So Lena's been working very tirelessly with the food service department, which handles a lot of the nutrition pieces, and working with the wellness committee and making sure we're positioned for this update. She is recommending that the current policy goes through in its current form. I did want to bring attention to the board. We started to use our website a lot more to communicate this information. So if you go onto our website, you go under operations, food service, and wellness, you can see some of the information we're sharing to the community. You can see the wellness assessment that is referenced in the policy that we're required to do. You can see the board policy, and there's some other wellness components that are maintained in there, keeping us in compliance with the district or with the requirements of this policy. So with that said, she does not recommend any changes to the policy.
All right, does anyone have any questions or concerns about policy 246? And
Move to get rid of the slash under number 3. Go down other way.
number 3?
Yeah, there's
Just an
well,
extra.
there's an extra something under there.
Sure, appears so.
Okay. And are there any board members online, Mr. Graham? Or I'm sorry, Mr.
Mr. Wagner.
Okay, Mr. Wagner, any questions or concerns about 246?
No, sir. All good.
Without objection, we'll move that to second reading at the October 14th board meeting. 802?
I'm going to handle all those together if it pleases the board. These policies are all up just because I'm cycling through the 800s. They're all very, very short, very more related to how the day operates. The calendar one is very short as well, like establishing our grades. There are no changes recommended for any of these policies, as we like to keep our policies very high level. So if we make small adjustments as an administration level, it's not something that needs to come back to the board.
Any questions or comments about 802, 803, 804, or 807? Mrs. Brady and then Mr. Donato.
My question was on 803, minor, and it probably is fine the way it is. But I know recently we've made some adaptation from the 180 school days to the number of hours. And I didn't know if the wording needed to change for that.
So we had some conversations around that, and it might be something that comes back to us. Normally consists of, we're okay with that language as of now. As I looked at a lot of different policies from different districts, PSBA and so forth, a lot of them get down to the 990 requirements. They get down into specific days, when those days will occur, how the calendar functions. Like, we like that this is high level. If it's something where we continue to take advantage of that new flexibility, it might be something where we just want to reference that. But that section below where we reserve the right to make some of those adjustments, we feel like we're positioned okay without really getting into the weeds on it.
Got it. Thank
It
you.
was something that caught my eye right away as well, though.
That's my question.
Mr.
I
Donato.
expected that one.
Same question.
Or, I mean, we could very easily add minimum of 180 days or whatever the number of hours are, and it would still be probably considered a de minimis change, but that's.
So I would recommend actually keeping it the way it is, because we have a potential, the only exception we have is what's underneath that reserves the right to alter the calendar when it's in the best interest of the district, but we still have to adhere to any other contract agreements. So those agreements are based on days. And so we have the ability to do less days as long as we're meeting the hours. So it gets a little more complicated if we start to add in hours when we're not, even though the law says we can. That's why that third sentence there helps us cover it, whether we want to do days or go less days and then meet the hours. So that I would ask probably is the best way to keep it at this point.
Are you saying because of like future building projects and things like that, or to be more
No.
flexible, or?
Typically, we would have 180 student days. And so when we look at other agreements that we have, whether it's the collective bargaining agreement, et cetera, it's based on days. And so we have the ability to go less days within reason, as long as we still maintain the hours, which is why that third sentence there comes into play, and that we can alter it based on the interest of the district. And we have provisions that we have to work within if we're going to alter it and go less days. But we still by law have to meet either days or hours.
They're all great. Go ahead, sir.
No, it's
These are all great questions, and some policies are addressed that way, but to really then capture all those things, that policy becomes quite long, and it is lengthy for other districts.
To get into the specifics, what you're referring to is a half a day counts as a day. But if you were counting hours, that would be less hours, for example, but that would count towards one of the 180 days.
So whatever we
If you have a
establish,
half day,
whatever we establish as the day that students are in school, that's the day. And so our calendars have always been built on days. This year we went off of hours because we have 2 less student days, which we worked out an agreement through the collective bargaining agreement to do that because of training purposes. But we still have to meet the hour requirements because we have less student days. So it starts to get complicated if you go down a day, you have to have the right hours and vice versa. So by saying that we're building off of days, that's how we do build our calendars, is the day. So if we want to alter the days, we have the ability by policy, but we still have to stay in line with any agreements that we have. We don't have agreements for hours. So it's clean to keep this policy solely as days at this point. If something were to change in the future where there's even more flexibility for that, then I would recommend we come back and change the policy.
And the hours are different at the levels, so there's
Right.
another complication.
You'd have to outline the elementary hours, the secondary hours. You have to back out passing time,
Yep.
non-instructional, like it gets super complicated. Days keeps it easy. And then we know we're doing it behind the scenes on the hours, but our calendar is built at 180. If we alter it, you approve it, we bring it to you as a board, but we can't go below 178. And that's not a guarantee we'll have that every year. We just have to look and see what makes sense as we go.
Any other questions or comments about 803? Mr. Wagner?
None from me, thank you.
All right, without objection, we'll move 803 directly to second reading on October 14th. Any other questions or comments about any of the 800s? All right, without objection, we'll move all of them directly to second reading, and we will turn to policy 351, which are some revisions to the drug and substance abuse policy. And tied in with that is the administration is recommending that we retire policy 351-1, pre-employment drug testing. So Dr. Musser, would you like to give everyone a high-level synopsis of what we're trying to accomplish here?
I sure would. So this should look familiar. We discussed this winter of last year as we were looking at how the pre-employment drug testing was impacting some of our hiring. We were looking at the cost of it. We were looking at the overall effectiveness of it and what was it really accomplishing for the district. At the end, we determined that it was a costly policy that really wasn't revealing or preventing anything that we couldn't prevent through improvements on our current drug testing policy. So that is how we got to where we are today. As we had the conversation with the board, and rightfully so, there were some board members that were concerned about the potential for lessening of any standards that the district previously held when it came to substance abuse and controlled substances. So there was some requests to explore some reasonable suspicion searches. It is a somewhat tricky area to work in, but at the end of the day, I'd like to call your attention to the highlighted section that's new near the bottom, the reasonable suspicion of drug abuse, substance abuse, and alcohol. If you want to scroll down a little bit farther. Thank you. So this whole section here was something that I did work with legal on that gives the district the ability to accomplish some of those same concerns that I believe previous boards felt were being addressed in the pre-employment testing. But now this gives us real time, so it's not held to just pre-employment. At any point that we feel that an employee is under the influence, we can go ahead and use these procedures and explore potential next steps without involving anything from the pre-employment standard. One of the things that I added to this is I added the definition of alcohol, which was not previously in this definition, because if we're going to go under this reasonable suspicion, we can also look at suspected alcohol use as well, which was not in the policy previous. We need to be careful with consent as it's referenced there at the bottom, but we work to have a failure of consent as something that the district can choose to address. Then if there is disciplinary action, we can weigh that accordingly. So it gets us around the requirement of testing as a government agency we're not able to do. So I know there was some conversations and questions about this. I've worked with Mr. Keener a little bit on this as well. We'd be willing to answer any questions that the board may have.
So, Dr. Musser, I guess to summarize this, and make sure that I understand this correctly, what the administration is recommending is that we retire the pre-employment drug testing policy and instead beef up the substance abuse policy so that if there's ever a time that we suspect that an employee is under the influence of alcohol, marijuana, or any other what we'll call hard drugs, we have a way of addressing that quickly and decisively.
Correct.
Okay. So with that, are there any questions or comments around 351 or the retirement of 351.1?
I'll start with the policy you want to retire. I don't have any innate concerns in retiring that policy. That's been the trend, I think, across not just school districts, but maybe even healthcare because of the cost and the fact that there are ways around that. I like the reasonable suspicion part with the first section. The second section of that, I'd like to talk about a little more. And the reason I'd like to talk about that is because it talks in here about the administration may make arrangements for the employee to consent to a drug or alcohol test to be performed by a medical professional. My concern with that, if there's zero teeth in that, first of all, if the employee is under the influence, do you really believe for 1 second they're going to consent to a drug test?
No, we can't force them. That whole section's from legal. We have to seek their consent.
I understand that. So if they refuse to consent, then we get into the second part of that where the administration, when determining an appropriate disciplinary consequence, I would love to see that tightened up a lot, that if an individual refuses to commit to any kind of drug test when they're clearly or potentially under the influence,
When there's reasonable
suspicion, if they refuse to consent to a drug test that's paid for by the district, at that point in time, I believe termination should be on the table. I think that's where this policy gets soft.
It does say,
Ms. Nesselman?
I guess the last part, that's what I feel like that covers. Considered by the administration when determining an appropriate disciplinary consequence. I think disciplinary consequence leaves it to what?
I really believe that decision not to consent to a drug test should lead to specific consequence listed in policy. And that's how I feel comfortable eliminating pre-employment drug testing, which I truly support. I just think this is very soft at the end of the day, and it allows for decision-making that could lead to, how do I want to say this? Somebody might be treated differently than somebody else because it's all done on subjective administrative decisions. Put the policy in there and make it firm. We're dealing with kids. We have a no tolerance policy with our drug policy with vaping with our kids. To have this soft just doesn't feel right.
Additional questions or comments? Mr. Wagner?
No,
No. Good. Oh, wait. Go ahead,
You're
Richard.
good. You're good. Go for it.
Mr. Wagner and Mr. Garber?
Yeah, I see where Justin's coming from. And it does seem a little open-ended to me now that he's kind of brought it up. But when I read through this policy and some of the changes, it didn't strike me like that. But it's true, right? I mean, there's a lot of open-endedness at the end of this. I mean, having that disciplinary consequence more defined, or having something in there that would actually, you know, call for something of a consequence would make sense to me, right? I don't know what that is, but you know, up to and leading to termination, or at least some kind of verbiage in there that that is part of the policy. I don't disagree with Justin on that.
Mr. Garber?
No, I was just gonna say, I kind of agree the same thing, appropriate discipline, what's an appropriate, we all could say what's appropriate, and we have a very strict policy for the students. Like, we have that spelled out, if they're caught so many times vaping, right? There is a
Right.
step
There's
process.
there's a multiple step process though for removal of a student.
Right, but what I'm saying is, so we have a more strict process for the students than this. This is a
So
more, we have a more.
Very
process.
general,
Right.
very
So I think we do need to tighten it up.
So what I hear you saying is, if I could work with legal and saying, legal's not going to be comfortable with going straight to termination
No,
on a
I don't think
sufficient.
it should be.
But you
straight
would say,
termination.
you would say that this is going to be a discipline for a first offense by just not acquiescing to the test.
Yeah,
I actually, first of all, I'm not sure why they wouldn't be okay with going right to termination, because this is exactly like DUI law at this point.
yeah, that's true.
And if we have implied consent for DUI, and if there's reasonable suspicion, the motorist either has to consent to a chemical test, or they lose their license for a year. And failing that, it eviscerates DUI law. Failing a serious disciplinary consequence for refusing a reasonable suspicion-based test eviscerates this policy. Because if I'm drunk or high at work, and all I have to do is say, no, I'm not going to take your test, we at that point don't have a way to enforce school safety. So I'm actually not clear on why we think that we can't go straight to termination, as long as there truly is reasonable suspicion, which the law defines as specific and articulable facts.
But I also look at it as if you want me to take drug tests, I'll take drug tests all day long, right?
Yeah.
If you have nothing to worry about,
they think
why would you not do it?
Just a thought suggestion here. When you look at that paragraph in its entirety, it says the administration, nurse, and or school resource officer. Technically, the nurse and school resource officer are the ones that would do the assessment and make some of those determinations. So we may need to look at that language, but then I would go down the path to go further. Then instead of saying the administration may make an arrangement, the administration will make an arrangement. And then it's up to, if the employee's failure to consent to that would result in fill in the blank working with legal, because you leave us from the administrative standpoint an open-endedness as to whether we can or will or won't schedule that test. So if you want teeth to it, then we need to actually make the appointment, and then it's up to the employee whether they're going to go or not.
However we want to do it to make sure that there's some teeth in this. I didn't mention this in the first part of the discussion, but I do feel a little bit sensitive to the fact that you're putting a lot of weight and a lot of pressure on those nurse and school resource officer to make decisions around this. And so I do think their opinion matters and what they can do matters. But more importantly, what happens later on with this is what really is going to put the teeth in it.
Yep. My point for bringing that up is we would refer to the nurse as a certified registered nurse and or school resource officer who is a police officer to make an assessment and then recommendation to the administration on, yes, we believe they should be tested, or no, we don't believe. And then we then at that point would schedule it, and then the employee has the decision to make.
And I think this is pretty highly unlikely that anything like this would happen, but in the unlikely event that it does, or the unfortunate event that it does, I would love to see that last part of this tightened up and not be so ambiguous and subjective.
Well, and if in the case of alcohol, it wouldn't be scheduled, they would simply be asked to submit to a chemical test. I mean, which the SRO can easily administer.
No.
Remember, we're looking for reasonable suspicion right now.
I
not
understand, but the
cause.
school resource officer line, we'd have to look at our agreement with East Hempfield on that as to that individual's role versus an actual police officer. coming
They
in.
are actual police.
I know, but their role is in function of the school and servicing students. Here, we're talking about the potential of a significant issue when it comes to employees. I'd want to check that to make sure we're not in conflict.
I'm not sure if they can, if it doesn't have to do with a breaking of a law. I don't think they
Well,
can just do it.
But
out
it
of
does.
suspicion,
Is it
but-
legal to be under the influence of alcohol or a controlled substance when you are a school employee on duty? I'm pretty sure that's
I don't know what the
unlawful.
state law is. Is that the state law?
Yeah, it's not just a violation of our
Yeah.
policy, it's also unlawful.
Okay.
I would want to,
So,
I just want to verify that,
Yeah.
looking at our agreement, so that we're not misstepping in policy that creates a situation where it would somehow be in violation of what we've agreed to with the police department.
Maybe it'll be something, Mr. Keener, as policy chair, you and I can connect with council. Council feels very strongly about the district's ability as a government agency to engage in
Okay.
some of those
like to be
processes.
part of that conversation because
Yes.
I tend to agree with Mr.
I-
Keener on
yeah.
this.
My understanding of the law is that we would be well within our rights to do this, but I'm happy to be told by the solicitor that I'm mistaken on that. It's pretty clear we're not going to be able to advance this from today's meeting.
Yeah.
Is it safe to say that the board is generally in agreement with Mr. Walgamoof's concern and how we would tighten up that language?
I think I have some concerns. I'm not sure that they're in the same alignment, but I have some concerns about also just going straight to dismissal as the end all on this one, that one. I really would just need different wording to
Okay.
consider.
Ms. Johnson?
Can I agree with both of you at the same time? Because part of it's kind of muddy. My experience has been as an officer in the military with clear legal authority, which I was more than happy to exercise. Being here is a bit different. However, we are charged with the safety and security, not just in terms of our buildings being safe, but of the people who are here to provide an education, care, and just to be here for our students. Is there a difference if you show up hungover, or maybe you did something the night before you shouldn't have? I don't know the degrees of how that shows up on drug testing. Or do we have people who are showing up and they are actively high or drunk? I don't want those people in the classroom. So I don't know what the solution is to that. I don't know the degrees of how much stuff is left in your system and how that affects them. And then if we have a teacher who is, and this, it doesn't even address this, this is just something to throw out. If we have a teacher that has some substance abuse issues, that's something also that really has to be addressed as well. So
I think we're mainly talking about if they deny the test. This doesn't address if somebody's struggling or challenging with it or
Right.
whatever. They test.
that is
fine.
correct.
This is only about people that say, no, I don't want to be tested. Like the law says with driving, if you say,
Right.
I don't want an alcohol test, you lose your license. Like it's straight up.
To refuse the test, but
Right.
there are consequences for refusing the test.
I think what I'm struggling with is, and I don't know if there are there any circumstances where you may appear impaired, where your clarity of thought may not be there, and what might lead you to reject the test, but you are not under the influence or high. And I don't know, like if you're in a diabetic situation, or a UTI can sometimes mess with how your brain is functioning. So I don't know how those play out because that's not my profession. But would that person then, if they are not in clarity of thought and rejecting a test, be fired for that? And as it
No,
turns out, they're
Mrs.
not
Brady,
under the influence.
if I may, that this is exactly, that hypothetical is exactly why we should have reasonable suspicion-based testing. Because even though in this case, the test would be exculpatory, the person might be showing indicia of impairment because of some other condition, but they're not really impaired by drugs and alcohol. So the reasonable suspicion-based test would be exculpatory for that individual.
But we are still required to enforce due process rights for an individual. And so in order to do that, we would have to do a more thorough investigation with that individual as to why they're refusing, and to understand, and if.
No, but they wouldn't, what I'm saying is they wouldn't refuse. That person should say, yes, please test. me.
But what I'm saying
Show
is if
you
they are
I'm not
that's not-
impaired.
If they are impaired and they don't have the clarity of thought to say, I should probably submit to this.
Yeah, that's what I think.
But that's where in the scenario, we would have someone with that individual. Obviously, our medical professionals, you know, our certified nurses, our health room nurses have that, some of the medical experience, they'll see something else is going on here. And we need some additional support or help for this individual. And so that's where we can adjust the language, but I think we still have to ensure, A, we're still following due process rights, but also making sure that we are seeking additional supports for that person in the event a medical professional, police department, whoever is dealing with the situation feels like something else is going on. So to that point, that's where you would need to really do the thorough investigation to then come up with a recommendation as to whether we're moving to termination or not. Because that individual would still have to sit for a louder mill to make here's what's presented. We have to go through all of those specific procedures, and we have the ability to still collect evidence as they would have to present it at that time. So it's not an automatic. You still have several steps that we'd have to work through. in order to
Well,
do
if you want to get in the weeds a little bit with that paragraph and you don't want to go straight to termination, you could go to an automatic suspension until that investigation's completed. And if they can produce medical records that show that they have a UTI from their doctor and that they had a diabetic incident, which usually you can tell the difference. And most people, if they're having a situation, are going to seek some assistance, not get pulled out of the classroom because they have alcohol in their breath or they smell like marijuana. So at the end of the day, I understand where you're coming from. I think it's very unlikely being in the healthcare world. What we find is when somebody's under reasonable suspicion, there are definitely behavior changes in that individual. There's definitely some things that create reasonable suspicion. And it's not just that, oh, my bladder hurts when I go to the bathroom and I'm starting to run a fever and sweat. That's not necessarily reasonable suspicion. Their behavior's changing. There's all those things that you look for. And if somebody's going to refuse a test, that's fine, but there should be some direct consequences to that, even if it's an indefinite suspension without pay until the investigation's complete, if you don't want to go to termination. But I still agree with Mr. Keener that when kids are part of this equation, or in healthcare, when residents or patients are part of this equation, it's a no tolerance policy.
So just some go ahead, Mr. King.
Mr. Wagner, do you have anything to add?
No, not at the moment. I honestly, I just appreciate the conversation. It's an important one. And so, Mr. Wogemuth, I appreciate you bringing it up initially. And yeah, I mean, it's, you know, Justin, you just mentioned it, a no tolerance. This is a no tolerance situation. And just a few minutes ago, I was thinking that exact same thing. I mean, at what point is this a zero tolerance piece? And in my mind, it's got to be. So, yeah, I just appreciate us looking a little deeper into it, remastering this, putting in proper language. This is something we don't want to play with, in my book.
Thank you, Mr. Wagner. Dr. Massa?
Sure. Just for context, and I certainly don't disagree. I feel like whatever we can put in to add more teeth and more steps and process in here makes a ton of sense. I just want to remind the board that the reason it's here is, unlike the vaping policy, it's not something we're doing to correct an issue. We're doing this because the pre-employment piece is going away, which didn't impact us at all. It served us in no way. It's not a problem that we're addressing. As I was working on this policy on and off for the last half year and looking at other schools, most people have standard PSBA language. We have right now, if you were even to look and take half of what we have, some of the most aggressive language in the area. I'm not saying we can't make it more aggressive, but there is a difference in we're not addressing a problem we have, but to your point, if there was a problem in the future, making sure that the proper process in place, both from the safety piece, both from the employee due process piece, and then from how does that end it all from a termination point? Because engaging in more policy that enters the district in lawsuits or additional costs in needless areas isn't the direction anyone wants to go.
I would just add that it also, by tightening this policy and taking away the pre-employment screening, will strengthen and add some teeth to the concern that I wouldn't even consider coming to work if I was under the influence. Goodness sake, take a day off if you need to, but don't show up. This policy will help to prevent somebody from making a poor decision during that time, especially if they think that we've softened the policy by pre-employment drug testing goes away, which again, I support taking that away. People find their way around that anyway, and it's expensive.
At the end of the day too, and I hesitate to go down this avenue, it also gives the board the flexibility to address medical marijuana and its application in a way without explicitly identifying it. I think there's only one district that I found explicitly identifies that. And there's a whole nother level to a little bit of Linda's point and Judy's point, medical pieces and other steps that go along with that can be quite time consuming. So I will be glad to, if Mr. Keener is amenable to it, and if anyone else would like to sit in that conversation. This isn't a policy that's up because I need it. This is a policy that was raised as a concern that we've been tooling away with. So we'll continue to tool away. I'd like to say I'll have something for October. I don't think we have major ground here.
Actually, what I would propose, Dr. Musser, is let's try to set up that meeting between now and with Mr. Walkamu, permission.
I'd be happy to be part of it if we can do a phone call or Teams.
Okay, and where I was going with this is if we could maybe have a little bit of time on 9:30, we can provide an update then. And leading off with that then, if we are in agreement about retiring 951-1, I would like to move that decision to first read on September 30th. Any concerns with that?
None at all. I think it's a great move.
Mr. Wagner?
No concerns from me.
All right, so what we will do is we will set an update on policy 351 on September 30th, and also a first read vote on retiring 951-1. Assuming it passes first read, we will then move to second read and retirement on 10/14. All right. Anything further for policy, personnel, and legal? All right, with that, you see the schedule for future meetings, and I would request a motion to adjourn.
So moved.
Motion by Mrs. Johnson.
Second.
Second by Mrs. Brady. Any discussion? All those in favor?
In
Mr.
favor.
Wagner?
In favor.
Motion passes. We are adjourned. Thank you.
Have a good night.